Thank you, Mr. Chairman. Thanks to both of you for being here. Mr. Strickland, I'd like to start with you, if that's okay.
Certainly.
As I'm sure you are aware, some observers, some legal scholars, and other analysts of this industry have contended that any protection from antitrust liability that ICANN may have enjoyed in the past, in fact, ended in 2009. Concurrent with a change in the level of oversight specified by the NTIA contract. However, there's a 2015 decision rendered by a panel of the U.S. Court of Appeals for the Ninth Circuit, affirming the dismissal of antitrust claims brought by namespace. And in that opinion, the Ninth Circuit suggested that some insulation from antitrust liability may still remain. More to the point, I think the Ninth Circuit's reasoning supports the conclusion that this continuing measure of protection, whatever it is that remains of the protection from antitrust liability, may fall away with the expiration of the NTIA contract, that if and when this happens, that somehow whatever insulation remains would disappear. In particular, the Ninth Circuit reasoned that it could not infer that ICANN entered into an anti-competitive agreement as ICANN's apparent insider-driven process for shaping the bidding process for new top-level domains was, quote, fully consistent with its agreement with the Department of Commerce, close quote. Now, by way of explanation, the court noted, quote, it was understood from ICANN's inception that its board would include industry insiders and that the board would approve the application process, close quote. So I'd like to ask you the question, given the uncertainty of the situation as far as antitrust law goes and the uncertainty that I think is acknowledged by the Ninth Circuit in this opinion, did NTIA reach out to the Department of Justice Antitrust Division for an opinion on possible liability risks that ICANN might incur, that ICANN and its board of directors might face following the removal of insulation from a normalized antitrust analysis brought about by the termination of the NTIA contract? Is that something that happened?
Yeah. During the evaluation of the transition plan, there was an interagency committee of federal agencies, including the Department of Justice. As part of that process, the Department of Justice looked at whether there were any competition concerns that might result from this transition, and they concluded that there were none. Now, it has been our view that ICANN has not enjoyed antitrust liability, not going back to its creation in the late 90s. So we have never seen the transition as taking away something that they hold today, because we do not recognize that they have any antitrust immunity today. And that is also the Department of Justice's view, so that the transition obviously then wouldn't change that circumstance, because if they don't have it now, they won't have it going forward. And so that was all evaluated as part of our overall review of the transition proposal.
Right, but you don't dispute that some courts have seen it differently. You don't dispute that.
Well, I'm not here to, I don't hold myself, excuse me, Senator, as an antitrust expert. I know the Department of Justice has offered a briefing for the chairman, and I assume members of this subcommittee, to go into that in greater depth. I am aware of a case, I think it's a 2009 case, that has been cited as providing some level of immunity. It's not really an antitrust immunity, it's more derived from sovereign immunity. But that case didn't involve ICANN, it involved a predecessor to VeriSign. The court case you're describing in the Ninth Circuit, the 2015 case, I thought the holding was there was no cause of action stated. I don't believe they made any finding of immunity as part of their holding.
Yeah, well, it was a different sort of ruling. They didn't find that that they were immune in the same sense that they would have been if they were a government actor, but there was this connection to the government entity that seemed to be significant in finding no liability then.
Right, but am I correct that they found no cause of action?
Correct.
They didn't dismiss the case based on any of those issues?
They found no cause of action. As my time is expiring, I do want to know, and actually, let me ask you this of you, Mr. Marby. ICANN is, of course, a nonprofit corporation, and it's organized under California law. And it has been since its inception in 1998. Is ICANN committed to remaining domiciled in California, subject to both U.S. and California law post-transition?
Yes.
Okay. So ICANN is not in a position of saying we want to keep our options open. It's committed to staying in California, remaining a California corporation.
As I said, the basis of ICANN is built around California law. That's the bylaws are funded on them. The charter of the organization is funded on California law. And plus that, the 2,000 plus contracts we have with different registrars and registers and other ones around the world are all based around California law as well.
Okay. Thank you. I see my time's expired.